the assertion by counsel for the complainant is that there is no allegation that you own Facebook. That's of course not true, because if you read page 208 again, it says, meanwhile, a Malema supporter started publishing updates about farmer tax on Malema's Facebook page every few hours. Now, assuming that was a mistake, the assertion is repeated on the same page. Another Malema supporter posted on his public page. Now, we're clear that's the positive assertion. I then crossed Mr. N's boots on this. And then he does a shift, these nuanced shifts that are fundamental. He then says, I did not exclude the possibility that he does not have Facebook. But on the cold reading of his text, it's a firm assertion. So in fairness to the witness, the version that has been presented in evidence in chief must be put to the witness. He can't chop and change for convenience. If that's the assertion, they must stick to that assertion. It can't now be, well, that's not their version. That's exactly the version.
It's very simple, my lord. What we've shown on the screen is Facebook, the website, and that there are a number of pages that say Julius Malema on them. The witness has said he doesn't run those pages, doesn't own those pages. The question that I've put to him is a very simple one. Will he denounce the contents of what is said? He might say, I don't know who that person is, but what they've said, I denounce it or I support it. It's a very simple question.
It's belittling for me to come sit here and be asked to condemn the comments of a fake account, my lord. I must be condemning comments of computers, of things that we can't confirm if these are real human beings, if these things are not written by the same people because they want to discredit us.
The essence of your answer, the essence of your answer is you have no knowledge about that Facebook page. You don't know who is actually posted. There possibly other people that we have posted statements on that Facebook. So you deny it. The question that's now being asked is, would you condemn them? As I understand, the answer is also, I can't condemn because I don't know what this comes from.
I can't condemn faceless people.
Okay. That's the answer, Mr.
I understand. So in other words, you do not condemn those statements. Is that your answer?
No, I can't condemn statements of fake accounts.
Okay. I'd like to turn to another statement that was made. You played footage, your counsel played footage of Thabo Mbeki at the TRC, and at the end of that, there is a statement by one of the commissioners about Simbamba. Now, the impression that's created is that Simbamba, the lullaby, is about breaking the neck of a baby. That's the impression that you've created. Is that correct?
Created by who?
Well, by the footage. Is that what the footage states?
Say, I don't know what that song says. It's in Afrikaans. And my counsel tried to interpret it, and I said, if that is the interpretation, it sounds violent. I
Yes.
can't make my children sleep through singing violence to them. But if you want to put my counsel on trial, you're free to do that.
I'm just going to put to you what the song is actually about, which is that the song Simbamba refers to Sin Mamba, which is to see the snake Amamba, and it is about breaking the snake's neck. It's not about breaking the baby's neck. I just want to put that to you.
As learned colleagues, you can have that discussion over tea. I didn't make those utterances.
I understand. Then I'd shown you a video of people wearing EFF regalia at Senegal, singing the terms, kill the Boer. And I asked you, are they EFF members? And you said, I don't know, I haven't checked their cards. Is that correct?
Yes, sir. Okay. You see, there's members, there's supporters, there's voters. These three are different categories of people. But in Senegal, you run a risk, I said to my lord, of saying this guy who's wearing black and all of that, he's a member of the EFF. And then this guy comes the following day in public and says, I lied under oath that he's a member of the EFF. He is not a member of the EFF, and he denounces me. So I can't sit here and take a risk of being accused of lying under oath because I can't confirm his membership.
Yes. Now, I'm very glad you drew that distinction for us about members, supporters, and voters. Do you exercise influence over your members?
Yeah,
And over your supporters?
yeah,
And over the voters?
yeah.
Okay. Now, outside of this court, are there members that are outside this court?
Yes,
Are there supporters as well?
absolutely.
And I assume they're also voters.
Yes.
Now, I'd like to show you a video of those members, supporters, and voters outside of this court.
Your Lordship, we're back here. The agreement earlier was whether this will form part of evidence or not will be determined by an application that my counsel undertook to present to the court, and then we'll deal with it there and then. Here we see it being played now as evidence.
My Lord, I think it's important that Mr. Malema is given an opportunity to respond to it. There have been new videos that have been added throughout the course of these proceedings, new documents. No. This is, in other words, this is one of the questions before this court is what Mr. Malema's views are on singing the chant, shoot to kill, kill the Boer, and what the party's views are on that. And I've shown evidence of the party, and there's a dispute as to whether it's supporters or members in Senegal singing the chant, kill the Boer. And now I want to put to the witness further iterations of that. He should be given an opportunity to respond to it, to be fair to him.
I'm not sure, because I say, it seems to me, and we've dealt with this complaint earlier, if I recall, unless it's a different video, the complaint that members of the Afriforum were blocked as they were exiting the gate, and the whole issue that led to the issue of contempt. As I saw those two complaints, they were contemporary complaints and not complaints that falls within the pleaded case. And if you go the route, it means I will then have to take that evidence into account. The question is the evidence properly before the court? I am ruled that for that evidence to be properly before the court, you need to put an application so that I can then consider whether that can properly be considered. And until then, I'm not sure whether it's properly then put the evidence before this court, because whichever way you go, as soon as you start cross-examining the witness on the video, that means that evidence is now before this court. And this court's mind being influenced by what they presented. And that may fall short of the proper evaluation of evidence.
Well, my Lord, let me put it this way, that the video is used in two different ways. The video is used partly to ensure that the proceedings in this matter are run peacefully. In other words, that all members of the legal teams will be able to access the court freely in and out. That was the first reason for the evidence being shown, and so that a ruling on that could be obtained. The second was to say, this is evidence of the party singing the song in dispute, and it must form part of this court's record. Now, an application can be brought, and the question as to whether that evidence should be considered by this court can be determined in argument. Now, at this juncture, in other words, what this court could do is, in argument, make a finding as to whether this evidence ought to be excluded, and then I presume Mr. Maleme's response to the evidence could also be excluded, but that the opportunity is now given to the witness to respond to it, and that the court can then disabuse its mind of it in the event that it finds that that evidence is inappropriate.
Why can't this evidence be admitted or be listened to, let's not say admitted, be listened to?
Yes.
And it's valued or whether it is accepted, be considered at the end of the case?
Well, two reasons, my lord. The first is your directive was that this will not be streamed in court for purposes of this trial because I have not consulted client on this. Now he's put in a position where he's asked to comment on something he has not had the benefit of consulting client on. And your ruling, your lordship, was, for that reason, the fundamental right, constitutional right, that client is entitled to engage with counsel on the subject matter before he's put on the stand on it. So I'm simply saying I'm just going by the ruling of the lordship.
The ruling Mr. Kasipoti right before deals with the issue of the people who are appearing on the video.
Yes.
Who were singing outside the gate of the court. And I said it would be unfair for the complainant to play the video and adduce evidence in relation to the conduct of people who have not been given an opportunity to say, yes, indeed, it's us there, and what we were doing, were we singing or were we not singing. That's the essence of the ruling that I made.
Yes.
Now, yes, I hear what you say. In the case of the present witness, Mr. Malema, you may have not been able to consult with him about the video, which brings a different turn to it. But what I was putting to you is the proposition made by Mr. Oppenheimer is the evidence can be heard, and it can then, at the end of the hearing, be weighed as to whether it's evidence to be admitted or whether any weight should be granted, should be given to that evidence.
Well, Your Lordship, if the understanding at the start was what my learned friend is proposing, perhaps it's something to be said. The difference is this. The purpose of this video being played on the particular day it was played was for one reason and one reason only. It was to ask Your Lordship to make a ruling about access to court. It had absolutely nothing to do with it being evidence. Now for the first time we're hearing that it's supposed to be part of the evidence. What we would have done if that was the understanding, my client is going to ask about who these members are. What song are they singing? Who are they? Can you identify them? On the spot. Surely that can't be right, particularly if it's going to have an implication on the outcome. All I'm simply saying is, Your Lordship, let's focus. Let's stick to your ruling. Your ruling was this can't be used as evidence until a proper application has been brought.
My Lord, a few things. The one is, my learned friend says, this is a surprise to us that this evidence would be used. It was the complainant's case that there were two reasons. The one is the proceedings, and the other one is that it must be included as evidence in the case. The second is that an application must be brought to determine at the argument stage whether it should be included or not. In other words, the court can disabuse itself of it. So, and this video has been provided to the other side from an earlier stage. They've had the opportunity to consult with it. The video has been available to them.
But the video was introduced for a different purpose.
It was introduced for two purposes, my Lord. The one was to protect the integrity of these proceedings, and the other one is to show that the party sings the song "Kill the Boer," and it's Mr. Malema can respond to that. I don't intend to ask him to identify the particular members. I'm just going to ask him to respond to.
Well, let me ask this question: this video, was it ever discovered?
Yes.
In terms of the pleadings.
Well,
at the beginning of this trial.
Well, that's not possible because, in other words, it occurs during the trial.
That's the point I'm trying to get to in trying to evaluate what approach one should adopt. If it wasn't discovered and it was introduced for those two purposes that you referred to, it was then allowed to be played in the court on the basis and the understanding that there was a problem that this court needed to attend to, which was members of Afriforum were being, or their movement and access to the court was being interfered with by members of the EFF. That was the real purpose for which it was introduced. But again, I go back to the ruling I made to say this video can only be entertained to be included in the main case once a proper application has been put before the court. Now, until that happens, or until that ruling is set aside, that ruling stands, that this video should not be used until the court has applied its mind as to its admission into the main case.
My Lord, if I might refer your Lordship to page 18 of the complainant's bundle. At paragraph 44, the complainant says, it is not the position that the instances referred to above are the only instances where the respondents have engaged in hate speech, incitement to cause violence and harm, and racial discrimination and targeting. The above instances were recorded on video, and they demonstrate some of the instances where the respondents have been guilty of hate speech. If this matter is referred to an open court hearing, the complainant reserves the right to supplement its papers, induce evidence to include other relevant information. In other words, the nature of equality court proceedings is different to ordinary civil litigation. It's an inquiry. It's not a purely mere adversarial system. Throughout this matter, the documents that have been referred to have been supplemented continuously. New things have been added. This is...
No, understand that, Mr. Oppenheimer, there is an instance where I think there was the book, the other book which
yes.
was introduced, came into the middle of it. But that was because both parties were in agreement as to what approach to adopt. But here now, the court is faced with a situation where there is a disagreement between the parties, and that's why I'm raising this question of whether the rules. I did not understand that this court necessarily means that all the rules applicable to guide the court in dealing with disputes and matters that arises has been put aside. Those rules still apply, but my understanding of the law is in applying those rules, the court has to be alive and adopt a much more flexible approach to dealing with the issues. But here we're dealing with a fundamental issue that relates to a witness who firstly wasn't present and when this incident occurred. Secondly, that evidence has not been formally admitted in court, and the court has expressly stated that it could not be admitted. But let me propose this as a way to resolve this and move forward. Mr. Kasiboto, let me address myself to yourself. You've had my view about what the status of this video is. The defendant's, the applicant, the complainant's case now is we would like to play this video and we would like the witness to comment on it. Your complaint is, yes, one, the court has already ruled that it must not be played until there's application to admit. Two, that this witness has not had an opportunity to be taken through what the video is about. That seems to be fair. However, at the same time, one has to balance that also with what they have pleaded in their papers and what was the agreement between the parties, not only here in court, but also in chambers. In fact, it was moved by both of you in chambers that I should be flexible in terms of allowing materials being introduced as we go along. And as I understand, that's in the spirit of why this court was constituted in the manner that it has by the legislature. What if the ruling that, or let me put it this other way, what if we were to say, in as far as this video is concerned, the use of this video is concerned, that matter stands down. once you have had an opportunity to consult with the witness, Mr. Malema, on the video, then that could form part of the application that could be brought. In other words, that application that I've already ruled upon could be heard. And if I find that indeed this video can be used in the main case, not in the interlocutory that was brought, then we may request Mr. Malema to come back. What's your view on that?
I've got a view on it, Your Lordship. If the court is so minded, can I literally take a minute to consult with my attorneys, take instructions, try and persuade them to my view, and then respond to Your Lordship in literally a minute?
Okay.
My Lord, I also have a suggestion that might obviate the need for us returning
Well,
back.
let's give him a chance so that he can hear you when you make this suggestion. Yes.
Your Lordship, I've taken instructions from my attorneys. My initial view was I have no issue with the video being played, precisely because, well, the client has testified to it. Sorry, Your Lordship. Yes. So the position is this, Your Lordship. We are happy for the video to be played, subject, of course, to what you've said. And I've just been told now that client's view is that it should be played. But my proposal is this, and of course I'm supposed to have instruction, but my advice to him now is, let's be allowed an opportunity to view the video, perhaps at tea time, go over it, have a discussion, and only after tea time we'll be allowed to comment on it, not at this stage.
Yes. Of course, Mr. Oppenheimer, that then comes to another issue of granting them permission to consult with Mr. Malema, because Mr. Malema is now a witness of the court.
My Lord, I think that's a very fair solution, and that, in other words, the consultation is constrained to that, in other words,
That
this issue. I think that's
issue.
fair. Then it means that we can proceed. I will pause this question until after tea. They can have an opportunity to consult and talk about it. I think that's fair. My learned friend has also asked, sent me a video this morning, which he would like to show to Mr. Malema to lead in a sort of form of evidence in chief. And I thought that the appropriate juncture to do that would be after cross-examination, that my learned friend can then ask the court if he can lead that evidence in chief, that if the court allows it, that I will be then given an opportunity to cross-examine on it, and then my learned friend can continue with re-examination.
But isn't that complicating things? Because now you cross-examine him on a video which is being contested. They then consult. By that time, water would have long been under the bridge. We know what re-examination means. Re-examination is simply to clarify.
Yes.
Although quite often in this court, practitioners tend to just abuse that privilege or right. They then go into like it's now beginning the case from the beginning. But the principles of re-examination is basically clarify what may have been raised. So what it means in relation to this video, you're taking away their right of leading evidence and making sure that their client understands what the purpose and the issues raised in the video is. So I just think maybe the best would be that if you can hold back your question on this aspect, that at tea break, we allow them to look at the video, and then with the rider that they're given permission to consult with their client on this specific issue only. They are only given permission to deal with the video. And I want to emphasize, because the last time we issued the ruling, and there's a problem with the oral ruling sometimes, is that the purpose of consulting with Mr. Malema while sitting as a witness, it's only limited to the video of what happened on, was it on Tuesday or Wednesday? Sorry?
It was the 9th.
The 9th, yes. What happened on the 9th at the entrance of the gate of the court, that would be only limited to that.
Maybe if you can assist Your Lordship, if you don't mind. I've been overruled by my client. He's happy for the video to be played now and to be questioned on it now. The second aspect is this, Your Lordship, without wasting your time, on the issue that was raised by my learned friend is the second point, which is the video intent of play. And we absolutely agree with Your Lordship. Our proposal to my learned friend was this. It would only be appropriate that by the time I come for re-examination, I would have led evidence in that video if my learned friend allows me to play the video. And then as part of this cross-examination, it can cross-examine on that aspect, and then I come after as a re-examination. So my proposal is this. This video is played, he's questioned on it, I will re-examine, despite me not being allowed to read evidence, or rather to take him through it. And then dealing with the second video, then perhaps before he continues with the cross-examination, we deal with our video.
Yes, but Mr. Kasiboto and also Mr. Oppenheimer, what are the consequences of that in relation to the earlier ruling and a position you had taken earlier? Because it must have a bearing on that.
Well, Your Lordship,
Or maybe I should leave the two of you to go and confide and come back to me and say this is what should happen. We know even in court order, parties can agree to abandon.
yeah. Well, Your Lordship, as I understand it, my client is happy for you to overturn the ruling in relation to this video, if my learned friend is so minded as well. I mean, of course, with the proviso that I'll be allowed to re-examine him.
Okay, let me make sure I understand, because this video has got two implications. There's the first implication, or the contention that you had put on earlier, where you said a formal application needs to be brought for the admission of this, the evidence on this video into the main case. And the court made a ruling on that. Now, what I'm saying is, from what now appears to be a common approach, is that it can be presented, cross-examined on it, you will then re-examine. My question was, what's the consequence of that to the earlier ruling? Because I'm saying it's bound to have an implication. I don't think it's a neutral, it would come out as a neutral outcome.
I agree with Your Lordship. The position is this, Your Lordship. Your ruling insofar as that the admissibility of the evidence is concerned, an application has to be brought. All my client is simply saying is he's happy with the proposal of counsel, overruling me by the
Okay.
saying he's happy for the video to be played, to be questioned on it, I re-examine, and a substantive application nonetheless has to be brought.
Thank you very much. Mr. Oppenheimer, you may proceed with your questions, and can we, I think you were just about to replay.
Yes, I think just given the long interregnum, it
I
might
think
be
the
worth
period
replaying
we've
it.
taken in debating this, I think for the benefit of the witness, let it be replayed.
Yes. Okay, let's get there. Mr. Malema, is it correct that are those people members of your party?
I don't know.
Are they supporters?
I don't know.
Are they wearing EFF regalia?
Yes.
Are they chanting the words, kill the Boer, the farmer?
Yes.
Do you denounce them doing that?
I don't. I told you I can sing it myself.
You can sing it yourself?
Yes, I said this earlier on. The people are being firstly pushed at the gate there. I don't know what happened, what is the situation there. Then they say, don't push, don't push, don't push it. Then from there they start chanting, kill the Boer, kill the farmer. I don't know what happened.
Now, Mr. Malema, what's so interesting about your case is that you've tried to walk this bizarre line. And you say, they've got the wrong man, I don't sing that song, I sing Kiss. And now you say, well, I would sing that song, and those supporters of mine are singing that song.
I said that when I started my Lord, that I will sing it. I just take a decision not to sing it. But it doesn't mean I won't sing it.
Let me ask you a related question. The complainant has sought in its relief to declare the song and the iteration of the song that includes Kiss as hate speech, and to interdict all three respondents, yourself, Mr. Ndlozi, and the EFF, from singing that song. If the court so orders that you are interdicted from singing that song, will you comply?
Well, I will respect the court, but the court would have declared that our struggle was a hate. Because we sing the songs that were sang by those who came before us. They were not haters, they were liberators. And their songs still have a place today. My Lord, as a younger generation in the struggle, we sing the songs those who came before us sang to put ourselves in the position they were before. And like we said, our songs are not in any way meant to engage in any literal engagement. They are songs for that purpose of the revolution, not to attack anyone. My Lord, from the times of Shaka Zulu until today, I've never heard that black people were given instruction to attack through song. When the Zulu warriors declared, Bulalan Abatagat, they were not singing, they gave a clear command. We don't give a command through singing. When it is time to give a command, we'll give that command. And therefore, singing will never be confused for command. It is what it is. It's a chant, it's a singing, and in African culture, singing is not taken in a literal meaning.
Now, your testimony yesterday, when we played your singing of the song, and I asked you what does shoot to kill mean, you said it is an instruction to kill.
I said to you, the one you're playing for me there, it's a chant. It's a chant, we're chanting. And when we give a command, we don't give a command through a song. Those who are responsible for different battalions and detachment will be given that responsibility to give a command. When O.R. Tambo said in the early 80s, render South Africa ungovernable and unworkable, the youth of South Africa throughout the 80s responded to that. He didn't do that through song. He gave a clear command through the January 8 statement of the ANC, which has always been regarded as umkombandlela, where the president gives command of what's going to happen that year.
I put it to you that people that listen to songs can understand the meaning of those songs and they can receive them as commands.
It's not true. Africans, at least I can speak for Africans, my Lord. Africans don't get command through song. We've always had warriors who led wars of dispossession. We've had our leaders who went underground, who were militarily trained. Never did O.R. or Nelson or Thabo Mbeki or anyone who came after them and before gave an instruction through song. The ANC January 8 statement, my lord, became popular because that's where command was always given, not the song. I'm still to wait, for example, where the masses of our people were given an instruction through song to go and attack.
Now, I'd like to give you a couple of cases where the words in that song have been used for attacks. Well, if I can refer the court to page 2612 of the case lines bundle.
It's a 261.
2612, 2612. Now, my lord, this is an article from The South African. The title of the article is "Couple Survive Brutal Farm Attack After Pro-EFF Slogans Painted on Their Door." That is an image of the house, and it states there, "Dibulu Ubunu, Viva Juju, Viva EFF." Now, what happened, what the article details after that, 6 weeks later, is that the residents of that house were then brutally attacked. So, Mr. Malema, I put it to you that the slogans in your chant are not just constrained to the space of singing. They have a real effect in the world. People are using those slogans, firstly, to intimidate people, and then secondly, to attack them. And that those words have real consequences.
My lord, the EFF was formed in 2013. This song was sang way before the formation of the EFF. And to say people are being killed because of an EFF song, as if this is in the founding manifesto of the EFF, it's bizarre.
It's the claim, this is the interesting thing that you do, is you try and create a straw man. So you say, it's not our song. We didn't write this song. Peter Makaba sang this song, but you sing it now.
Yes.
You have embraced the song. It's part of your repertoire.
But you call it
chant
EFF
the
song.
Is it not an EFF song?
It's a struggle song.
Is it a song sung by the EFF?
My lord, the EFF cannot expropriate this song without compensation. It belongs to the struggle. It's a struggle song.
Is it a song that the EFF sing?
We sing it, yes,
You sing
but it's not, to coin it an EFF song, that's being short-sighted. It comes long before that. But secondly, my lord, these things that are painted here in red, firstly, I don't know who painted them. Secondly, I don't know if this is a pro-EFF supporter. What if it's Roots who painted these things? Because there is competition amongst white farmers. So it can't be entirely correct. What if the perpetrator and the murderer used this to divert attention from the actual suspect so that police are following the wrong lead? You are a lawyer. Please do better than that.
That sounds incredibly conspiratorial. In other words, if we are faced with two options, the one option is that someone who says Viva Malema and Viva Juju, referring to you, and uses words sung by the EFF, intends to intimidate and harm white farmers. And the other one is a conspiratorial view that Ernst Rutz himself is painting on these walls in order to try and set you up. I would say that is an entirely improbable view.
You are using wrong words as a lawyer. You must be clever than that. I'm saying not to set me up. I'm saying to divert the possible direction of investigation. So you kill my lord, and then you drop an EFF t-shirt so that there's natural suspect should be the EFF, while the real perpetrator is free because he diverted you. We don't know if the court in this case where people were killed arrived at a conclusion that indeed these were EFF people. We don't know that these people were caught and they're EFF members. We are shown an article here with a picture which we don't know where it was taken. We don't know if it's real. So it can't be correct that because it's written EFF, automatically it means EFF. The enemies of the EFF can also do that. I told you of agent provocateurs, which existed even during the time of the struggle.
I'll ask you a couple of simple questions then. Would you, let's be agnostic as to whether an EFF person wrote that on that wall. Would you denounce that? Would you say that an EFF person ought not to write that on people's walls?
Any EFF person who kills anyone is a murderer and therefore must be condemned and be dealt with through the laws of South Africa. So whether he wrote EFF and killed a farmer or a black person, he's a murderer. And his actions will not be inspired by the revolution, but by criminality.
Now, I'm glad to hear you say that you denounce the murdering, but I asked you a different question. My question was, if an EFF member were to write that on someone's walls, which are Dibulu Ubunu, Viva Malema, Viva Juju, would you denounce the act of writing it on the walls from an EFF member?
I denounce everyone who killed people, and that includes EFF members.
I'm asking about the act of writing. In other words,
Which one?
spraying that graffiti on someone's property. Do you denounce that action? I'm not asking about the killing.
Denouncing graffiti what?
Yes, would you denounce a member of the EFF putting graffiti on someone's house that says Dibulu Ubunu, Viva Juju, Viva Malema?
No, I won't.
You wouldn't denounce it?
No.
Okay.
Yeah. Graffiti is part of the struggle. We used it a lot. Yes.
Second part of the question is, if that same person would go out and do graffiti or write on the wall, the EFF, what would be your attitude on it?
The person who committed murder goes out to write that. No, we won't be associated with that. We'll condemn that. Because we are no party of murderers. And we don't want supporters who are murderers.